Welcome, folks. We'll probably wait another minute or two as participants are rolling in. All right, so why don't we get started? Hello again, I'm Dan Horn, and I'm the Associate Dean of Engineering for Professionals. I'd like to welcome you all to the very first session of our Distinguished Speaker Series. If you don't know about Engineering for Professionals, or EP as we call ourselves to save 7 syllables, we're the online graduate division of the Whiting School of Engineering. We have 22 master's degree programs, over 6,000 students, and 600 faculty members, many of them on staff at the JHU Applied Physics Laboratory. Now, online was the operative word in that description. One of the biggest challenges for an online program like ours is to generate a sense of community among its students and faculty members. So with this series, we're leveraging a common approach in on-site programs, bringing community members together to listen to one of the many experts among us and facilitate a discussion. But since this is online, we're pleased that we can extend the boundaries of our community to include members from other Johns Hopkins divisions and even alumni. I should be clear that this was the brainchild of my colleague, Heather Stewart, and she'll be leading the Q&A part of the hour after we hear from our speaker. So let's jump in. Lawrence Husick will be speaking today. When I asked him for his bio, Lawrence said, "I'm an obsolete chemist, patent attorney, serial entrepreneur, counterterrorism researcher, teacher, husband, father, and grandfather in no particular order." He's very humble, so I'll brag a bit on his behalf. Lawrence is a partner in Lipton, Weinberger, and Husick, an intellectual property law firm in Malvern, Pennsylvania. He's the founder of several entrepreneurial ventures, including Infonautics, PocketDoctor.com, Neuromo, and Cloud Pharmaceuticals, where he serves as Chief Innovation Officer. Lawrence serves on the boards of the American Helicopter Museum and Education Center, the Clear Vision Foundation, the Muhlenberg College R.J. Sampson Fellows Honors Program, and he's the past chair of the Board of Visitors of the University of the Sciences Sampson College of Allied Health Professionals. Lawrence teaches a course entitled Management of Innovation in EP's Information Systems Engineering program. So, without further ado, we'll welcome Lawrence Husick for his talk entitled Manhattan, Moonshot, DotCom, and WarpSpeed, U.S. Technology Policy for the 21st Century. Welcome, Lawrence.
Thank you very much for that wonderful introduction, Dan. Truly appreciate it. And welcome to all of you. This afternoon, what I would like to discuss with you is the policy of the United States federal government toward innovation and innovators, and particularly toward our patent system. I'm going to share my screen and start with the slides and give you the first too long didn't read summary so you know where we're going. And that is, for the past 20 years, Congress and the courts have been hostile to patents and inventors. And that has led to a deterioration of our global leadership in technology and in federal technology policy in general. Now, to understand where we are, we have to understand where we've been. So we need to step back a little bit into history. I bet you didn't think that you were going to get a history lesson as part of an engineering presentation, but there you go. We are going to step all the way back to August 22nd, 1787, and a man named John Fitch. Fitch was a prototypical early inventor, and in a dream, it had come to him that the power of steam could be used to propel a canoe. And since he had seen Native Americans paddling their canoes up and down the Delaware River near Philadelphia, where he lived and worked, he proceeded to build what you see there, a steam-powered canoe. Having built it, he did what entrepreneurs before and since have done. He sought out the richest people that he could find and tried to pitch them on backing his innovation. In this case, there were a bunch of rich people meeting in a building called the Pennsylvania State House, that building today you know as Independence Hall. And they were working hard on trying to come up with a new form of government for the newly independent former colonies, now states. They were the Constitutional Convention. And so Fitch approached the delegates to the convention, invited them to walk the 6 blocks from the State House down to Front Street to the river to take a ride on his new steam-powered canoe. And a great many of the delegates did so. They were impressed enough that Fitch thought some of them might invest. Ultimately, none of them did. But Fitch and the country came away with something far more important than a few dollars invested in a steamboat, because those delegates returned to their work and decided that innovation was central to the future of our nation. And so they drafted Article 1, Section 8, Clause 8 of the US Constitution that you see on screen before you. This is known as the Patent and Copyright Clause. Now, understanding the language of the Enlightenment requires us to tease apart which is patent and which is copyright. At first glance, you might think that the progress of science is the patent part, but if you were Mr. Jefferson or Mr. Madison or Ben Franklin, you understood at that time that science meant general knowledge. And so the patent language is actually the progress of useful arts. Useful arts is the Enlightenment term for what we now know as engineering. And so they gave us Article 1, Section 8, Clause 8, the Patent and Copyright Clause, which is one of only 2 parts of our Constitution that requires that Congress actually do something. In this case, set up a method by which authors and inventors might have the exclusive right to their work for a limited period of time. This was so uncontroversial that in supporting the Constitution, James Madison in Federalist number 43 actually hearkened back to the general laws, the common laws of Great Britain, to say that because the British had invented the copyright, which was a private right, we might do the same for patents. No one objected. The language sailed through without comment, and it has remained thus part of the Constitution. Now, patents, as you just saw, confer exclusive rights. And an exclusive right is the right to exclude someone from doing something. In the case of patents, the exclusive rights are the right of the inventor to exclude others from making, using, selling, offering for sale, and importing whatever the invention might be. And so patents tend to be pretty important. In my course, one of the books that my students read is William Rosen's The Most Powerful Idea in the World. It's a book about steam engines. But, not to be the spoiler, the most powerful idea in the world, according to Rosen, is not the steam engine itself or even the Industrial Revolution. It's the idea that you can have an exclusive right in an invention which allows an inventor to guarantee a return, if he is successful, to his investors. It's the idea that a patent promotes the formation of capital necessary to execute on the technology. That is truly a powerful idea. And it has been a powerful idea in propelling technology in the United States ever since. Now, as the title of this talk implies, we have had some major technology programs that have been true winners in the United States. And since World War II, those have included the Manhattan Project, the project to build the atom bomb, our trip to the moon with the Apollo program, the building and deployment of the internet as first a resilient network to survive nuclear attack, and then a propeller of commerce in unbelievable ways. And finally, WarpSpeed, the effort of the last 18 months to develop and deploy a workable, effective vaccine for COVID-19. These programs have a lot in common, but technology policy from the federal government is what ties them all together. Now, the theories of why you need a patent system go beyond this formation of capital idea. We have patents in order to provide an incentive to inventors to do what they do. Now, over the course of my career, I've worked with many, many inventors, and I can tell you that even without patents, most inventors would continue to tinker, continue to invent. So I'm not real sold on this one. But the incentive to disclose an invention is truly important. What we want is not keeping the inventions and how they work secret. We want people to be able to build on the technology that they can find in the literature, and patents function as an important part of the technical literature. The acceleration of disclosure is another part of that, the idea that it would be better to get there sooner rather than later. Isaac Newton may have said, "I am great, for I stand on the shoulders of giants," but of course he wasn't the first one to even say that phrase. It goes back 350 years before Newton. Standing on the shoulders of giants, however, is the way we build a technological civilization. And the incentive to commercialize an invention, that's where that formation of capital idea comes in. Finally, the creation of patents allows us to create markets for what we call intellectual property, all sorts of proprietary rights, not only in technology, but in trademarks, in copyrights, in all sorts of advances. And the idea that these things can be sold freely and can be used in licensing transactions creates its own form of economy and economic growth. Now, if we look at the history of the United States, we find that the federal government has been involved in funding of research and development for a very long time. But that was usually done under the guise of mapping and agriculture. And so this is a short list of the ways before much of the 20th century and certainly the 21st that the federal government funded these kinds of research expeditions and standards. By the beginning of the 20th century, the standards knit into the standards for food and drugs and so forth, and eventually the regulation of aircraft, necessitated because the aircraft were flying over people who got worried about what was going to go on. It was truly World War II that stimulated American technology policy as a separate consideration. And in 1939, Einstein and Szilard wrote to the president, FDR, urging him to engage in funding a research project intended to create the atomic bomb. This was a defensive move because they knew that the Nazi government was doing the same. And so in 1940, before we entered World War II, FDR created the National Defense Research Committee in order to coordinate and fund that effort. Eventually, that became the Office of Scientific Research and Development. And the head of that office had been the dean at MIT, Vannevar Bush. And when he was interviewed toward the end of the war, he was very clear about the need for a technology policy. If we'd been on our toes in war technology 10 years ago, he said, we probably would not have had this damn war. At the end of the war, at the end of FDR's life, FDR asked Bush what he thought technology could bring to the peacetime after the war. And the result of that effort was that Vannevar Bush produced a monograph called Science, the Endless Frontier. Science, the Endless Frontier was delivered after FDR's death, but would shape the way in which the federal government interacted with the rest of the country to move technology forward for the benefit of the economy and for the benefit of the military. That document was the basis for the National Science Foundation. And the structure that Bush envisioned was a partnership. Universities, particularly the great research universities, would form the basis for science research infrastructure. Federal money would generate research, but just as importantly, it would generate researchers. It would fund students. The awards would be competitive and based on merit, and the Science Foundation would manage that process. The research would then be let into the market in a very laissez-faire approach to commercialization. The important part of this effort was that we would create research and researchers using federal money. This tripartite agreement allowed us to accelerate research and development, to create new products and new markets, and move those products and the result of the research to market more quickly than had ever been the case before. And from the end of World War II until the early part of this century, it worked famously. In fact, if we look at that period, more than 65% of all economic growth after World War II came from technology innovation, and almost all of it was touched in some way by federal funding that supported the universities and their departments and their researchers. More than 70% of the economic growth that I just talked about came directly from university laboratories, including, I should say, APL at Johns Hopkins, which started during the war to produce the proximity fuse and since has delivered many economically important innovations, including things like our GPS system, without which most of us would be terribly lost 24/7. However, there were difficulties coming because from the time of the early 1960s onward, the percentage of federal budget money that went to funding non-defense R&D and total R&D fell rather steadily. Now, the slack was mostly taken up by private industry, and particularly by the formation of venture capital, which relied on a strong patent system. As anyone who's ever been an entrepreneur knows, one of the first questions venture capitalists ask is, what is your unfair competitive advantage? And by that they mean, are you protected by patents and other proprietary rights? If the answer is yes, you can proceed to the next step. But if the answer is no, that's often the end of the conversation. And so as the federal support for research and development waned, private support took up some of the difference. And the Bayh-Dole Act, which made sure that funded research stayed with the researchers, helped to briefly stimulate that at the beginning of the 1980s. But hostility toward technology has always been a part of the American society. Hostility toward experts is nothing new. In fact, in the 19th century, we had an entire political party called the Know-Nothings, and that should find some echoes today. We can look to the contract with America in 1995 as an example of that hostility. From 1972 to 95, the Office of Technology Assessment, part of the Congress, performed analysis of complex science and technical issues, built some of the first databases online of technology, and helped to move federal laboratory technology out into the marketplace. In 1995, Gingrich said the Congress didn't need to understand all that mumble-bumble stuff and literally dismantled the office completely. Its databases were frozen and transferred out to the ERIC system under the Department of Education, and have never been updated since. Now, the parts of the federal government that are openly hostile to innovation don't just stop with the Congress. The judicial branch has also from time to time illustrated its hostility. Back in the 19th century, all appeals of patent cases from trial courts went directly to the Supreme Court, and it was not unusual to see in a given year 20 or 30 opinions from the Supreme Court on patent matters. The justices, therefore, became very familiar with patents, and in fact, the rest of the government followed. Abraham Lincoln, in fact, was very pro-patent and even had a patent in his own name for a system for lifting boats over shoals in the river. But after a period of time at the beginning of the 20th century, when Congress took that direct appeal right away from the Supreme Court and moved it to the various circuit courts, the Supreme Court became largely silent and largely ignorant of patent matters. That changed in 1941 in the Cuno engineering case, when, despite what the patent law said, which was that literally anything invented by human beings could be patented, the Supreme Court decided that in order to be worthy of a patent, it was not merely engineering skill and prowess that was required, that it was something more, that it was a flash of creative genius. And you may remember that there was a movie a few years ago called Flash of Genius, all about the battle between an inventor and the Ford Motor Company over the intermittent windshield wiper. How you demonstrate a flash of genius was never really clear. But under that standard, the Supreme Court took the opportunity to slice and dice many, many patents by simply saying any good engineer could have done it. This doesn't show what that creative genius flash is. That eventually, 11 years later, caused Congress to get into the act because the Patent Office, an expert agency charged with helping inventors to achieve their goals, decided that this was untenable, that we couldn't define this. It was an I know it when I see it standard. And so the Patent Office sponsored the new Patent Act in 1952, which at its very opening in the first section of the act stated, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement, therefore, may obtain a patent, therefore. That meant that anything under the sun could be patented. In addition, they wanted to teach the Supreme Court a lesson. So in Section 103 of that act, the Congress specifically provided that patentability shall not be negative by the manner in which the invention was made. That was a direct congressional effort to slap the Supreme Court and to convince the Supreme Court that no flash of genius was required. And the result was a reassertion of patents in the economy. Now, our patent system from the mid part of the 19th century to the end of the 20th century was fairly stable in what it considered and awarded. As Lincoln said, the patent system added the fuel of interest to the fire of genius, and he knew what he was talking about. That's not just interest that exists in terms of people being interested in patents, it's also interest in financial terms. The first thing that we knew was that patents were awarded to the inventor. The inventor had to be the one, and the first inventor was the guy who got the patent. We knew that there was a grace period of 1 year from the time you invented something until you had to file. And that was good because it allowed inventors to show around their invention and try to accumulate some support, because it was still fairly expensive to get a patent. We knew that no matter how long the Patent Office took to process a patent application, the patent would last 17 years from the date it was issued, so that bureaucratic delays were on the patent office and not on the back of the inventor. The law specifically provided that once issued, a patent would be presumed to be valid in any court proceeding. And finally, we knew that if there was infringement, the inventor was entitled to an injunction against the infringer, the court telling the infringer to cut it out, to stop infringing. And that's what an exclusive right is, the right to exclude someone from doing something like infringing your patent. And that was very stable for more than 100 years. But in 1995, for reasons that have never been clear to me, a number of the bureaucracy said the rest of the world employs a 20-year patent term from the filing date. We should be like them. And so the Congress moved to change the rules and to institute a 20-year term from the filing date. There are some tweaks that if the delay in the patent office is really unreasonable, some time is added back to that 20 years. But it still puts the onus of the delay on the inventor. Shortly after that, in 2006, the Supreme Court disturbed the injunctive relief standard by saying that it had to be a balancing test. And this is how the balancing test played out in the case of eBay versus Merck Exchange. eBay was found to have infringed a patent for electronic commerce that was held by Merck Exchange, a very small company. And when it came time for Merck Exchange to obtain an injunction, eBay said, wait a minute, there are tens of thousands of sellers on eBay who depend on us for their living, in effect, to sell Beanie Babies. On the other hand, Merck Exchange is just a few inventors. And you, the court, should balance off those tens of thousands of people's income and livelihood against the expectation of some gold that comes from their patent on the part of Merck Exchange. And of course, the court looked at that and said, on a balance of harms, we shouldn't shut down the tens of thousands of people. And thus, anytime a patent holder asks for an injunction, that same calculus is put into play. And injunctions, therefore, are incredibly rare today. Now, in addition, in 2013, the America Invents Act was put into place. And as you'll see, that act was really aptly named as the exact opposite of what it was intended to do and what it in fact did, because it changed us from a system that rewarded an inventor who was first to asking inventors to race to the patent office because the person who got the patent was the first inventor to apply. It eliminated the 1-year grace period, meant that you had to race to the patent office all that much more sooner. It eliminated the presumption of validity. And so now you could attack a patent in very many ways. And finally, the courts had already eliminated this injunctive relief standard by putting in the balancing standard. In effect, we just gutted our own patent system. The judges of the Supreme Court have also been hostile in recent years. And so despite the anything under the sun standard that I discussed earlier, the Supreme Court has determined that there are exceptions that they have crafted to what may be patented. That, for instance, laws of nature may not be patented, and physical phenomenon and natural materials may not be patented. Now, you may recall that the Patent and Copyright Clause says that inventors are to receive their rights in their discoveries. And yet the Supreme Court has literally read the word discoveries out of the patent law. In the case of Mayo versus Prometheus, a case dealing with how to determine a correct dosage of a medication, the court simply said that there were steps from which anyone with skill might draw the correlations, despite the fact that no one had understood the correlations before the inventors came along. Now, in addition to those laws of nature and physical phenomena that have been excluded, we got in 2014, in the Alice case, the idea that abstract ideas were not able to be patented. In that decision, Justice Thomas said, in any event, we need not labor to delimit the precise contours of the abstract ideas category. And as one commentator has put it, tongue firmly wedged in cheek, the abstract idea is itself an abstract idea. But abstract ideas have been used to disqualify from patenting lots and lots of really valuable, and in the opinions of most judges, and in the opinions of almost all patent attorneys and certainly inventors, wonderful inventions. Inventions in the biomedical field and computer field are especially likely to be termed abstract. So why did we do that? Why did we gut our own patent system? We did so in order to get rid of the trolls. Trolls? What are trolls? Well, trolls are also called non-practicing entities or patent assertion entities. And what they are is anyone who has a patent right, but instead of building a factory and manufacturing and distributing and selling the product, seeks to collect a royalty from someone else who will do those things. We know who those trolls are. We know them by different names. They are sole inventors who have no intention of building factories. They're research foundations that hold the rights from universities. They're university professors who got the rights back from their universities, graduate students in the same right. Patent licensing companies that accumulate patent rights in portfolios of patents and then provide those groups of patents to going industrial concerns. Technology development companies that do that, but then further develop the technology before passing it on under license. Small businesses that may invent useful things, but things that are outside their main line of business. Owners of defensive patents who are just trying to have a patent so that others don't get patents on their core technology. And finally, patent pools, which are ways in which groups of companies cooperate in order to accumulate patents so that they compete with each other in the marketplace rather than banging each other over the head in court fights. A few years ago, I was involved in a major patent battle, and an expert witness for my client was Professor Polk Wagner from the University of Pennsylvania Law School. My opposing counsel asked him under oath in a deposition to define a patent troll, and this was his answer under oath. A patent troll is anyone who would dare to sue me for patent infringement. So where did the term come from? Well, the legal department at Intel Corporation was tired of being sued by university professors over the patents on their advances in chip technology. And they were in particular incensed at one lawyer who was taking these cases on contingency basis. They got together and decided to give that lawyer a name, and they called that lawyer a patent troll, and that name has stuck. In order to fix the troll problem, that is the problem of people who own patents but want to collect royalties for them, the Congress responded in 2011 with this America Invents Act, which changed our patent statute forever. In addition to changing the things that I've already talked about, the first inventor to file rather than the first inventor, and the elimination of our grace period, it also gave us 3 ways in which patents could now be attacked inside the patent office after they had issued. The inter partes review, the post-grant review, and the covered business method review were all ways to go after a patent and have it declared invalid without taking it to court. And those methods of invalidating patents have been used quite frequently. The Congress said that they would be quick and inexpensive, but I guess you have to be a congressman to think that what happened is either quick or inexpensive. The law specified that these processes had to occur within 18 months, and most of them do within 18 to 24 months. But the average cost for an inventor to defend his patent against one of these challenges is somewhere between $300,000 and $500,000. Most independent inventors can't afford that. And finally, the law eliminated what we call joinder in cases of patent infringement. If 5 people sneak up on you in a dark alley and hit you, you can sue all 5 of them in one court action. But if 5 companies infringe your patent under this law, you'll have to file 5 separate infringement lawsuits, likely in 5 different courts around the country, and try to manage the concomitant expenses and complexity of those. This is one way that Congress sought to choke off patent litigation. In fact, we can simply say that since the Alice decision, patents have been under siege. We can prove that statistically because in the Court of Appeals for the Federal Circuit that hears all patent appeals, 80% of the challenged claims have been found to be ineligible for patenting. And bear in mind, these are patents that have passed through the patent office, been examined by professional examiners, have been invested in by their owners. And yet, those patents are being invalidated without any trial, without any findings of fact, without any testimony whatsoever. This has led to what economists call efficient infringement. Efficient infringement is economists speak for, oh, well, so sue me. Large companies, rather than seeking to take licenses under patents, simply use the technology and dare the patent owners to come after them in court. When the patent owners occasionally do take them up on that challenge, those large companies draw the cases out, run the expenses up to the point where the inventors simply give up. Don't think this is a case? The case of the Microsoft mouse, the first successful hardware product marketed by Microsoft, is a case in point. An independent inventor from Texas got a patent on the mouse shaped like a bar of soap and took it to Microsoft under a non-disclosure agreement. Microsoft at the time said, "We're a software company. We don't have hardware that we sell." 1 year later, the Microsoft mouse was the best-selling product in the company's history, and they didn't want to pay. There was a lawsuit filed. That lawsuit essentially went nowhere. So who benefits from a weak patent system? Well, as I've discussed, giant corporations that can simply use the technology without having to pay for it. Foreign competitors, particularly in the Far East, the manufacturing economies, and in somewhat of a turnabout, the healthcare systems of poor nations. You may have been reading in the press recently about a waiver program that was being considered where the patents on the COVID vaccines would be waived. Well, this has been going on for some time, particularly India and South Africa are 2 countries that manufacture many proprietary medications, but without the niceties of licenses in many cases. China is particularly adept at playing the patent game. In 2004, as you can see here, China was not among the top nations in filing patents. And yet, over the course of the last 15 years, China has been quite aggressive in developing its patenting strategy. And as you can see, in the last 10 years, China has gone from number 4 to number 3, and more recently, leapt ahead to become literally the top of the chart in the last 3 years. China's ascension in patent filing has not, however, been accompanied by a change in Chinese patent law. And so in China, there is still a requirement that if you get a Chinese patent, you have 3 years in which to choose a Chinese partner that will be a majority owner of the venture and begin to exploit the patent. If you miss that deadline, the Chinese government has the legal right to take your patent, assign it to a Chinese company, and dictate the royalty rate without any right of appeal. In China, pharmaceuticals get little or no protection from the patent law, and that removes a major component where the US leads the world. And finally, in China, the lack of uniform rules for pretrial discovery mean that you may never find out the details of an infringement going on, and it is very, very difficult to prevail against a Chinese defendant in a Chinese court for a foreign plaintiff. All of this means that in China, the table is truly tilted. History teaches us that having a strong patent system and a judicial and legislative branch that support innovators means a dynamic economy. 4 facts that we need to keep in mind. People everywhere are smart and capable, and it is a truism that there are more honor students in either China or India than there are students in the United States. Science and technology advance relentlessly, and knowledge flows everywhere. The internet is therefore a democratizing factor in the world, but it's also an atomizing force because a country like China can put its internet behind the Great Wall, the Great Firewall. Stability is not particularly enhanced. So we are left with the conclusion that globalization happens. How can the US sustain its competitive advantage in technology? Well, here are the ways. We need strong science and technology education at all levels. We need a free market economy that promotes the formation of capital. We need a rule of law that respects proprietary rights. We need a diverse population that can contribute to the intellectual capital of the country. That's how we remain ascendant in technology. But the facts on the ground should be worrisome. According to the most recent global surveys of the OECD, the United States now ranks 11th in math and 30th in science. Our free market is increasingly burdened by protectionism, by tariffs and by restrictions. As I think I may have convinced you today, these judge-made exceptions and congressional actions and inactions mean that the rule of law as it relates to intellectual property is increasingly weak. And finally, that diverse population is harmed by restricted immigration, by policies that encourage bright students to come and achieve, to earn their advanced degrees, and when they do, immediately sends them back home rather than allowing them to remain here as part of our economy. The result may be that we are forfeiting our lead in technology through our own actions. And as Pogo famously said, we have met the enemy and he is us. We have no alternative but to re-examine and re-strengthen these factors that lead to technology domination. It's good for the United States, but we have generated technology and donated it to the world in untold numbers that have benefited world populations. We need to continue to do so. Our successes of the past must allow us to continue. Manhattan, Moonshot, DotCom, WarpSpeed, all successful programs. And I would suggest to you that the next major technology program that we need to tackle is Thunberg, is the idea that we need to solve climate change. And the investment of the United States in its universities to produce research and researchers, to allow their intellectual property to be moved into the market is the surest way in which we can do that. I thank you for your attention and I look forward to your questions and our discussion following.
Thank you, Lawrence. That was really insightful. I enjoyed it. Thank you so much. So we'd like to open for questions. If you'd like to submit a question into the chat, please do so. We'd like to ask that you include your name, what school you're with and your status, if you're a student, a faculty, an alumni, or other. And to get us started, we have a few pre-submitted questions that we received during the registration process. So I'll turn it over to my colleague, Alicia Magruder, to start with those.
Thank you, Heather. Thank you, Lawrence. That was awesome. So the first question we have, and I think you touched on this a little bit, but let's start here. How will COVID-19 reshape the US technology trend, and how will we adjust our policy to meet the challenge? And this was submitted by Brian Yang, who is a student at the Whiting School.
Excellent question. Well, I think COVID-19 has demonstrated that our institutions need to be more flexible, that the way in which we approach research and development needs to be diverse and multi-centered. Certainly the development, testing, approval, and deployment of the various vaccines for COVID-19 have their roots going back at least 20 years in the mRNA side, at least. But I think ultimately this project of accelerating the process is going to be a pattern for us if we're willing to take the lessons. The combination of federal dollars and private research, as well as the urgency that was necessary to make sure that we streamlined but didn't shortcut the regulatory approval process, meant that we were able to field a vaccine in record time. I think that the technology involved in the COVID vaccine is going to revolutionize all facets of healthcare. My prediction, frankly, is that in 20 years, we will look back on the healthcare of 2020, and we will think of it in the same way we now think of the use of leeches and bloodletting. That's how big a change it is. But we need to be prepared with a technology infrastructure that can take that fundamental leap and move it into a variety of different fields, a variety of different uses. And we need to be sure that we are rewarding those who did the basic work, and that we continue to reward those who will come up with new materials, new processes, new techniques. Unfortunately, we're never quite sure what the courts are going to do with this. And I personally think that it is likely that when the courts get to eventually looking at mRNA, they will look at it and say, that's a naturally occurring material. And as a naturally occurring material, it is a law of nature and not subject to the patent laws at all. And that's one reason why I think Congress needs to once again have a 1952 movement, that Congress needs to repudiate the present approach of the Supreme Court, rewrite the patent laws to assert that anything invented by people under the sun is capable of being patented, and then move forward so that we see the kind of jump in technology production that we did immediately following the 1952 Patent Act.
Thank you. Okay, our second question that we picked from the many that were submitted is from Valerie 2. And the question is, how does US technology policy today shape what devices consumers use?
Well, I think policy in the past shapes the devices that we use today. The clearest example of that, of course, is the internet, and the development of the internet and the commercialization of the internet led us to a point where we were able to build functions and products on top of that basic messaging network. And that has given us, for better or ill, online shopping and social media and lots of other things that have benefited us or harmed us, depending on your point of view. Technology policy today will have the same effects. And so we need to know what that is. Another good example of that is GPS, which we originally deployed just for military uses. but now finds its use in literally everything. And again, for better or ill, technology, in my view, is value neutral. It is all up to the people who use it. So I really like having GPS. It allows me to get where I'm going efficiently and avoid traffic, and I use it in the car and so forth. But we all know that GPS is part of what is being used to track us around the world, and we've got to worry about our privacy. Those policies ultimately make themselves part of the market. And that's part of our laissez-faire approach to moving technology developed in university research laboratories into the commercial marketplace. The one thing that we know is that it is nearly impossible to predict all of the ways in which that technology will find a home in people's pockets, but we know that it will.
Thank you. So this other question that we have, and if we don't have any more questions coming into the chat, we'll ask some from the pre-requested questions. But the last one from the ones that I pulled is from Teddy Lee. And this question is, how would the leadership in global science and technology contribute to helping underdeveloped countries?
Often we are told that the United States and its capabilities and technology have been used for ill. I think that on balance, that is not true. There certainly are instances where our technology advances have not benefited the less developed countries of the world, and certainly the poorest people of the world. But if you look around the world today and you look at, for instance, rates of poverty, which are the lowest they have ever been in history, general well-being, general health, which is the highest it's ever been in history, the freedom and self-determination that women have to pursue their own path in life because of the advances in healthcare that have come from the United States. We have been, I think, generous, but in a capitalist way. We've certainly been compensated for our technological advances, but on balance, I think they have generally aided the world in a great many ways. I can name many more, from the Green Revolution to the ability to have renewable energy, all sorts of things that ultimately will change the balance in favor of bringing people to a higher standard of living, a higher standard of education, a higher standard of health, and a higher standard of freedom. It's not linear. The progress is not always forward. Sometimes it is the classic 2 steps forward and 1 step back. But I think on balance, if we look at the ledger for US technology, the technology that we've developed and deployed has benefited the poor of the world, and often more than those who are better off.
Thank you, Lawrence. I have a next question for you. This is coming from Jesse Hallworth. Jesse is a student with the Whiting School of Engineering. And the question is, how do the benefits and effectiveness of government funding of research and technologies compare to that of private funding?
Excellent question, Jesse. The funds are pretty much interchangeable. And so we've developed in the United States a collaboration between government funding for more basic research and commercial funding, private funding, for the translation of that research into services and products in the marketplace. Sometimes the handoff between the government and the private funding is not very smooth, but they cooperate together in order to do what Vannevar Bush envisioned back in 1945, to produce research which is then moved into the marketplace by commercial forces. These days, when you apply for certain types of government funding, the requirement is that you provide a plan for commercialization. And that makes sure that the government funding is not going to something that has no applicability in the real world. So that is one of the hallmarks of the applied nature of government funding. But there are lots of programs that are more fundamental to basic research, and those continue. And the basic research continues in both university labs and now in government labs as well. So there is a whole matrix of organizations, from government organizations such as the National Institutes of Health and the National Science Foundation, as well as branches of the military and the intelligence community, that fund basic science and basic research. But in addition, many of those organizations look toward commercialization and have relationships with private funders. In fact, the CIA has its own venture capital fund, which is the ultimate crossover. So I see them as being fully synergistic.
Thank you, Lawrence. All right, we have a question from the audience now. This is from Manaz Mazari. And the question asks, is technology policy in alignment with sustainable development goals and DEI?
I'm not sure I know what DEI is, but the United Nations Sustainable Development Goals are an aspirational set of goals for all of the member nations to achieve a better standard of living, better health, less poverty, better freedom. And US technology policy in many cases aligns with those, particularly because of the actions of US agencies like USAID, which is fully capable of propelling US technological development into the world. Another kind of example of that would be the PEPFAR program, in which the US funded the development of treatments for AIDS, for the virus that causes AIDS, and then funded a program to deploy those in Africa. So all of those types of programs do in fact support sustainable development goals. And though occasionally at odds, I think in general, the development of additional technological solutions and better understandings of the way the world works and the universe works generally give us an advantage, and we have not been shy about sharing that advantage with the world.
Thank you, Lawrence. And DEI is the diversity, equity, and inclusion.
Learn a new acronym every day.
Okay, I think going to be our last question. Do you foresee US adopting policy and technology toward mitigating climate change, or will we also fall behind in this effort? And this question comes from Chris Cooper, who is a student with the Whiting School.
Chris, thank you for that. I think it is generally acknowledged that we have already fallen behind, that we may have fallen behind irreversibly, but I am confident that as pressure builds on us, we will continue to increase our efforts to mitigate the problem. We have to recognize that one of our greatest failings as a nation is the pluralism that equal values everyone's opinion. It's a failing of our political system and not of our research and development community. As long as the political system has control over the way in which we attack the problem, we will remain behind, because the political system is subject to many pressures, both commercial and cultural. As the effects of climate change become more undeniable, as the world comes to see that the disruptions caused by climate change, things like crop failure, additional damage from intensive storms, migration, as those things increase, we will no longer be able to ignore them. And eventually they will rise to the level that the political system is forced to take action. Will it be too late? I don't know that there is a too late. I think what these problems become is exponentially more difficult to solve and more expensive to solve. but we'll have to deal with that as our political system allows us, because that's the way that our system is set up. I think we'll get there. I don't know when.
Thank you. Lawrence, I want to extend our appreciation for you so freely giving your time and expertise to us this evening. This has been a very enjoyable webinar, and we do appreciate it. I also want to thank the attendees for joining us at our first Distinguished Speaker Series. And I want to let everyone know that we have 2 additional series lined up, one October 13th. Excuse me, I'm sorry, that's wrong. One October 21st at 4 p.m. It will be cybersecurity awareness and the ever-changing threat landscape. And then our second one upcoming is going to be November 8th, and that is the renaissance of synthetic aperture radar. So we hope that you'll join us for those upcoming seminars as well. Thanks, everyone. Take care.
Good evening.